So yes, today we are going to discuss about John Locke and his natural law theory. Now, say his idea of social contract uh, and the natural law are two different things, though. This is something that I should start with. Okay, natural law is not an outcome of contract, you know, among human beings. Okay, that's not the case. Natural law already exists. Okay, something that you know, in his case, in Locke's case, something that you know uh, through your experiences, and not just experience, you also apply your reasoning capacity. So you need both these, unlike the previous thinkers who would say that even in the closed room, if you close your eyes and contemplate, you will come to know about natural law. Here's how John Locke is different, because he's an empiricist, as many of the British philosophers are known for. Their approaches empiricist, in the sense that something, your knowledge is based on your experience. Okay, so all knowledge can only be based on experience. Of course, you apply your reasoning capacity, but you cannot apply your reasoning capacity uh, on a blank slate. So how do you feel that blank slate, that tabula rasa? That is through your sensory perception. Okay, so yes, this is the difference essentially that you see in John Locke's natural law theory. But he is known more for his idea of natural right. Okay, so natural rights are basically some kind of claim rights, okay, that you have even before you come into a human society. You entered into a human society from the state of nature. You always had natural rights. Now, why do you have natural rights? We are going to go into all those. So I'm just introducing these ideas at this stage. So you'd say that by virtue of being humans, you are entitled to certain rights. Okay, and when you enter into a society, the government's role is to protect your natural right. Okay, so when government violates your natural rights, you are morally justified in acting against the government. So something that Thomas Hobbes will not be that easily okay with. Okay, Hobbes doesn't say that in no case you are justified against the sovereign, but then the threshold is much higher, because he's a child of fear. Okay, he is from Thomas Hobbes was from a completely different period when for example, Charles I was executed. So, and then there was fear of Spanish incursion. So he was a child of fear. So he wanted some kind of authority over completely crazy individuals, okay, who in the absence of this sovereign power over them will be at each other's throats. Okay, and life was poor, nasty, brutish, short, etc., that he talks about. I'm not going into details. Okay, but he creates a very bleak idea of state of nature where it was absolute chaos. Okay, so to save us from that, we need a human society. Okay, where and then there'll be one lawgiver, that will be the sovereign. It need not be monarchy, but it has to be some sovereign. Okay, who will have a great power over you. For what end? To attain civil peace. Okay, so here's some similarity that you will see. Okay, how Thomas Hobbes takes on this issue with that of the later version of Saint Augustine. Okay, they all say that the laws here, the human laws, are for a very humble purpose. Okay, it is not for some divinely ordained purpose. Okay, it's merely for maintaining civil peace here, in the absence of which there will be chaos. Okay, so that's the very humble purpose for which law exists. Okay, now there are many implications of that theory that he talks about. I'm not going into all that because we're going to spend our time on John Locke. Now, unlike Hobbes, Locke creates a different kind of picture. Okay, Now the question that you might be wondering about is whether the state of nature that they are talking about, okay, and the contract, the social contract, both of them are social contractorian. I'm assuming that you guys have already studied that. That's why I'm talking like this. So the social contract that the humans enter into, okay, and then by virtue of that contract they enter into a society. But prior to that, what existed was state of nature. But unlike Hobbes, it's not chaos like that. You still had, there was natural law still there, and so did you have natural rights in the state of nature. But you need some neutral arbiter to decide matters, because there are certain other issues. What if there's a disagreement that arises between two individuals who both think that they're right? So you need a neutral arbiter to decide the matter, and hence you need some neutral judge to decide the matter. So anyway, what I'm essentially saying is that both of them conceptualize some kind of contract. Now the question is, did the contract really happen, or is it a hypothetical contract? So in other philosophers, like other contractorians like Immanuel Kant and John Rawls, there's as they clearly say, is a hypothetical contract, whereas in the case of these thinkers, they nowhere say so, but we are probably to assume that yes, the contract in fact happens. Okay, now how does it happen? You have to study them thoroughly too. In fact, I have shared a reading. You will see certain discussions that have already been made there. Okay. So anyway, so that's the idea of contract that they talk about. Apart from that, John Locke says that even in the state of nature, there are certain natural rights, okay, that you are entitled to, okay, and that cannot be violated, that cannot be taken away from you, okay, and government exists so as to protect those rights, okay, so it cannot take away those rights, okay. So that's the idea of limited government that you hear now. That's the idea of constitutionalism that you hear now. So a government that is limited by the law, okay, there is rule of law. A government that is limited by the law, a government that is not arbitrary, okay. So that's the essence of John Locke's theory. So this is something that you need to keep in mind, because prior to these ideas which have been created, it was quite confusing before that. I mean, the kings used to think that they have almost a divine right to rule over you, so they can do whatever they want to. So these ideas were path-breaking. In fact, the Bill of Rights, 1688, in England, English Bill of Rights I'm referring to, the first idea of constitutionalism emerged through that, okay? And John Locke's philosophy definitely had an effect on that. And then subsequently, of course, in the American Constitution and their first 10 amendments, the Bill of Rights as they call it, you clearly see the effect of John Locke's theories. And that's the importance of this guy. So even though you might find many inconsistencies in the theories that he laid down, but nonetheless, a great portion of his work is of great importance. It's path-breaking for the time when he had created them. So you must study them. Even when you want to disagree, you should disagree once you read and understand his philosophy. So let's start with what Locke had to say. Okay, so Locke has two important contributions that we are going to refer to. First, the two treatises of the governments, and of course another important one is essays concerning human understanding. So that's the one. In the essays concerning human understanding, you get the idea of natural law that he is talking about. And in the treatises, you get the idea of ideas related to law that he talks about, okay, civil laws, etc., that he is talking about. So yes, these are the two very important works, contribution that he has made, okay. So in the two treatises of government, he talks about the idea of rule of law, as we understand today, that we are a country where there is rule of law, okay. it's not the whims and fancies and dictates of one glorified leader. It's not meant to be. We are supposed to be a rule of law. Now, rule of law has been said to be antithesis of arbitrariness. Basically, what is arbitrariness? Based on whatever I think, okay, based on my wishes and desires, okay. I am not bound by some other pre-existing laws. That's arbitrariness. Whatever I wish and desire will be the law. But Locke will not have that. Okay, so he talks about the idea of rule of law. So he says those who govern are bound to do so by duly promulgated standing laws. So if just for the sake of understanding, so if I am to govern, then I cannot be governing based on my whims and fancies, but based on duly promulgated standing laws which have been proclaimed, declared, okay, and those are standing laws in the sense that they will not be changed now and then at the whims and fancies of those who are governing, okay. And then he says, which along with known authorized judges, why does he emphasize on authorized judges? Because you have to know who's going to decide. So those judges who decide the matter have to be the ones who are already authorized. So this he contrasts to the extemporary arbitrary decrees. Okay, so extemporary arbitrary decrees are an antithesis of rule of law. So that's the idea of rule of law that he's talking about. So laws have to be duly promulgated, and they have to be standing laws, and disputes that arise have to be adjudicated only by known authorized judges. Okay, so that's the idea of rule of law that he's talking about. Now, one of the important feature of such a law that he is referring to is that these laws have to be written. Okay, written laws are out there. You know that it has been laid down. Oral laws, okay, everyone will have their own version of it. Okay, and it creates confusion. So, rule of law also requires that laws are written. Okay, whereas these laws that we are referring to are the laws which are made by men. Okay, we do not say the same thing about law of nature, because law of nature is out there in the nature that you find through your experiences and by virtue of applying your reasoning. Okay, that's unwritten. But the laws that govern you here now in the civil society, okay, that have to be written. Okay, that's the idea that he's talking about. So do not confuse that even laws of nature have to be written. They are obviously unwritten. Okay, so one of the important features of this idea of rule of law that he is talking about is law's prospectivity. Okay, that law has this virtue of being made before the event to which they might be applied. Okay, so it is, the event should be like this, the order of the event should be like this, that first there should be law, then something happens to which the law is applied. That's the prospectivity of the law. It should not be otherwise, that the event first happens and based on that event laws are made. So this is a very important feature of the human laws that he's talking about. In fact, it is an important feature of the idea of rule of law that he's talking about. Okay, that's another essential feature of the idea of limited government that you will study in constitutional law later on. So these are the foundational ideas that were laid down by John Locke. Okay, so he must have laid this down for the importance that these ideas have. Okay, just imagine a society in which there is no law. Okay, there is no rule of law. It will be absolute chaos. It will be basically reverting back to the state of nature. Okay, that is something that you don't want. Hence, yes, the necessity and importance of the rule of law. So now, what is arbitrary power then? What is arbitrary decrees that he is talking about? He says that absolute arbitrary power is governing without standing laws. So that's why he says that rule of law is antithesis of arbitrariness. Okay, arbitrariness means governing without standing laws. So government has to govern only when they have justification of standing laws. Okay, And if that happens, okay, if the government governs in the absence of standing laws, then you do not merely revert back to the state of nature, because in state of nature you still have rights, okay, natural rights, okay. It is even worse than the state of nature, okay. So this is the importance of rule of law. Rule of law ensures that your natural rights are protected, that natural laws are upheld. So yes, civil laws have to be in accordance with the laws of nature, which basically means natural law. When I'm using the word laws of nature, I'm not talking about the physical laws of nature, obviously not. I'm referring to natural law. So he says that the ruling power ought to govern by declared and received laws, and not by extemporary dictates, and undetermined resolutions. So this is the different way of saying the same thing, that whosoever is ruling you have to govern you only by the laws that have been declared and received, okay, and not by extemporary dictates, not by my own whims and fancies, okay. So that's the essence of the idea of rule of law. Another important aspect of rule of law that you will find in your constitution, okay, when you discuss about Article 14, okay, all these things will be discussed but from constitutional perspective, but those ideas had their germ in these philosophies, okay. So another aspect of the idea of rule of law is that there is something called equal subjection of law, okay. So what does that mean? That everyone will be equally subjected to the general law that exists, okay. That rules of law are not to be varied in particular cases. It should not vary for someone who's close to the government and some beggar on the street. The law have to be equally applied to all. So everyone has to be equally subjected to the law, okay. Now here, and one important idea that you see is the idea of equality. So where does this idea of equality come from? It's from the because it's from the idea of natural law itself, okay, that everyone is equal, okay, under that law, okay. Everyone is God's creation, as he would say, as we will study later on. So everyone is equal, so everyone has to be treated equally. But in practice, of course, I mean, you will see certain inconsistencies about certain other remarks that he makes, but we are not concerned about all that. Let's focus on the theory here. So he says that in the state of nature, everyone is equal, okay. So even when you enter into the civil society, everyone should be equally subjected to the law. There shall not be differences, discriminations when the law is applied in particular cases. So rules of law are not to be varied in particular cases. So that's another very important aspect of the idea of rule of law. So are you guys clear with his ideas so far?
Yes, sir.
So keep these ideas in mind. You will see that when you are taught constitutional law, when you are taught about Article 14, this is essentially what your teacher is going to talk about, but from a constitutional law perspective, okay. Now this very idea of a constitution, what is a constitution? A foundational document in a particular legal system, isn't it? Constitution is a document that limits the government. It lays down how the government is to function. So very idea of constitution is based on Locke's philosophy. Constitutionalism is the idea that a government is limited by the law, that it is not like absolute, it is not like unlimited. There is certain restraints, limitations on what the government can do, and that restraint, limitation was imposed in the on the government in the works developed by John Locke, which you see prevalent in the legal systems around you, okay. So yes, so that's the importance of the idea of rule of law that John Locke is talking about, okay. So yes, we are all subject to the law, equally subject to the law. Now one question that then arises, that if we are all subject to law, are we then free? when we are under the government. Okay, so he has to come up with an idea to say that yes, we are free under the government. Okay, when are we free under the government? When the government is not arbitrary. It's the laws that the government is laying down has to fulfill all the requirements that we have just discussed. Okay, and it cannot be against the higher laws of nature, higher natural law. Okay, if that is the case, even when you are subjected to the law, you are a free man. Okay, you are enjoying freedom under the government. So it says that it is to have standing rules. So what does freedom of man under government mean? He says that it is to have standing rule to live by. Okay, common to everyone of that society and made by the legislative power erected in it. Okay, so the freedom in the sense is that everyone is subjected to the same common law. Okay, common to everyone. Okay, which is made by someone who has that legislative power. That could be the mechanism that we have created. Okay, so for example, in our case, the legislatures which are out there making the laws. Okay, so our freedom under the government would be our subjection to the law. Okay, which is not arbitrary. Okay, which is not against the natural law. And what are the specific liberty that you exercise? The specific liberty that you exercise is essentially what is not prohibited by the law. Okay, so that's the liberty that you exercise. Now, you might raise questions then. What if most of our liberties are curtailed? Okay, his theory will not probably allow most of your liberties to be curtailed. For example, will it allow all your properties be taken away from you? His philosophy will not allow that. Will his philosophy allow that all your freedom of movement or freedom of speech be taken away from you? His philosophy will not allow that. Okay, so why do you need the rules then? So that when your freedom, your liberties come in conflict with someone else, then there has to be someone else who has to decide the matter, and that's why you need the government, and that's why you need those authorized judges to decide in cases of conflict. So yes, when you are subjecting yourself to the government, you are not losing your freedom. In fact, you are getting protection of your freedom. Okay, so what is a liberty then? He says that so you have liberty to follow your own will in all things. Okay, which things are those? Where the rule prescribes not, and not to be subjected to the inconstant, uncertain, unknown, arbitrary will of another man. So essentially is saying that you do what you want to. Okay, but it shall not go against something that you are prescribed from doing by the laws which have been laid down. So essentially the mechanism is for the competency of different divergent liberties and freedoms that humans might exercise. So they will come in conflict with one another. Hence you need some mechanism that will ensure that you enjoy your liberties while you are not subject to some inconstant, uncertain, unknown, arbitrary will of some other person. Okay, so that's the idea of freedom that he is talking about. So you do not really lose your freedom, you do not lose your rights. Okay, when you subject yourself to the laws of the government, because those laws, if they possess the other features that we have just discussed, okay, then of course you don't. But if they do not, if the laws are arbitrary dictates, then of course you lose. Then you have the right to raise your voice, overthrow the government if it is an extreme case, of course. So yes, that's the idea of law, okay, that he is talking about. So if that is clear, then let's proceed to the idea of natural law that John Locke talks about. So the laws that we were talking about so far were the laws that you find in a civil society, okay, for the governance of the people. Now there is another law that is higher to that law, okay, and those laws made by humans, laws in a civil society, have to be consistent with those higher laws. Okay, those are the laws of nature or the natural laws. Now you see that here we find that Locke is more on the line of what Thomas Aquinas was talking about, that yes, human laws have to be consistent with the laws given by God. Okay, so John Locke is also on that specific matter taking a similar stand. Okay, but how do you identify natural law? On that, John Locke will have a different position than what Aquinas had. So you see that Augustine's philosophy, later philosophy, had similarity with Hobbes, and Aquinas is a lot common with John Locke. So let's look at what natural law according to Locke is. Okay, so as I told you, when we talk about natural law, you will find that idea in the book by the name Essays on Human Nature. Okay, so there you will find that. Okay, so so there he talks about what is natural law. Okay, so in Essays on the Law of Nature, he says it is something so manifest and certain that nothing can be plainer. Okay, so what does that mean? So what is a natural law? He's saying that it is so manifest. Okay, everyone knows it. I mean, it's out there. If you care to just look for it, it's out there. Okay, and certain, there is no question of uncertainty in it. Okay, so it is so manifest and certain that nothing can be plainer. But it's easier said than identifying what actually is the natural law. So this is what the position here in Essays on the Law of Nature here. Okay, so in second treatise also he refers to the natural law, and there he says that natural law is plainer than even positive law. Okay, and then he says that as such, as much as reason is easier to be understood than the fancies and intricate contrivances of men, following contrary and hidden interest put into words. So you can say, I mean, if it is so plain that you can say when it is natural and when it is not. Okay, so this is what he is talking about. So even then we do not exactly know, I mean, these two different sentences here that we have just read does not yet tell us what exactly natural law is. So let's look at something else that he had to say. So then he says what natural law is not. Okay, so he says that natural law cannot be traced from opinions. Okay, because you will have one opinion, I will have opinion, someone else will have some opinion. So natural law cannot be about opinions, because we will all be in disagreement about our opinions. Okay, so opinions quite often are biased. Okay, so hence there is a high chance of them being in disagreement with one another. So that cannot be the source of natural law. Nor can customs or traditions be source of natural law, because those are also products of time and place. Okay, so unlike some other previous thinkers who would say that some customary laws of a place are nothing but the laws of nature manifest in their customs, this is not what he is saying. He is saying that no, customs and traditions are outcomes of a particular place and time. So that's definitely not natural law. Because sometimes forget about an individual. Okay, individuals quite often, for example, they commit murder, they commit other crimes, heinous crimes. Okay, sometimes even an entire nation can flagrantly violate natural laws. Okay, hence natural law cannot be said to be an outcome of opinion, not just of an individual, not even of a nation. Okay, so what then is natural law? Would he subscribe to the idea that natural law is innate in human beings, okay, human mind? Okay, no, he doesn't subscribe to that either. Okay, so unlike the other, for example, all the Stoics who would say that it's something that is innate in human being. Yes, what is innate in us is our capacity of reasoning, but natural law in itself is not innate in human being. Okay, so where else does natural law then come from? Okay, so in essays concerning human understanding, that's very essential, because that's where he tells you how you come to know of natural law. If it is not innate in human mind, how else do we come to know of natural law? So that you get in his essay concerning human understanding. So here's something that is very important for you that you need to know. So let me first tell you what he says about how we come to know of natural law. He says the truth of natural law had to be discovered by proper exercise of reason on the material provided by senses. Okay, very important. Okay, truth of natural law had to be discovered by the proper exercise of reason on the materials provided by the senses. Okay, so this is where his approach is different from metaphysics. Okay, you quite often hear what philosophers do it. There is this jocular way of saying that a philosopher is someone who's trying to find a dark cat in who's blindfolded and who's searching for a dark cat in a black cat in a dark room. Okay, so what does that essentially say? That says that okay, someone who closes his eye and just thinks about things. Okay, and then they say that okay, I got this. Okay, I came up with this idea. So far natural law that we have studied has been of that kind. Okay, that's something that if you contemplate, if you reason, if you close your eyes and reason, then you come to right conclusion about what is natural law. So here's how John Locke disagrees with that approach. So he's saying that we do not have any innate idea of what is natural law. Okay, you cannot know that. You cannot close your eyes in a dark room and then say that okay, this is what natural law. He's like, that's complete nonsense. So what does he say? What is his addition here then? He says that yes, reason has a special power, purpose here. Okay, but that purpose is served only when you have something on which you apply the reason. Okay, so your senses are very important. Okay, so your perception of the world through your senses is very important. So without the sensory perception, you cannot possibly know about what is natural law. So that's the important contribution that he has made. Now here's something, I don't have much time, something that I want to introduce for today so that we can proceed from here tomorrow. So if you remember when we were discussing in CLS or CLS classes earlier, we used to discuss that how common law has this quality of being empirical in nature, whereas civil law is deductive in nature. Okay, something that we had discussed earlier. What did I mean by that? Okay, so here's the thing, there's a specific approach to knowledge, specific approach to knowing that had emerged in England known as empiricism. Okay, that how do we know what we know? Okay, so empiricism says that humans have no innate ideas. Okay, we acquire ideas only through perception. Okay, without that we cannot acquire ideas about the world. Okay, so you have your sensory perception, you can taste, you can smell, you can see, you can feel, etc., etc. Okay, through that you acquire certain ideas about the world. Okay, if you did not have any, just imagine yourself, okay, as a being with no sensory perception. What are you then? Okay, according to them, there's nothing then, there's nothing really there. Okay, so Locke would say that humans are born as tabula rasa, as empty slate. Okay, but as we grow, as we experience the world, we acquire ideas about the world. Okay, and when we apply reason to what we experience, we come to conclusion about what is natural law. So I hope you understood what this idea of empirism. Okay, so a simple example of that will be, you have heard about this, all swans are white. Okay, all swans are white. How do you know that? Would anyone tell me here before we go? How do you know that all swans are white?
So because I have never seen any black swan.
Yes, exactly. So the moment you see that there's a black swan, well, then that that proposition falls apart, doesn't it? So that knowledge is only based on what you have experienced so far. So far, you have not seen a single swan that is black in color, if you may, to say that uh, you know to say that all swans are not white. Okay, but so far you have seen that all swans that you have come across are white. That's why you are saying that all swans are white. But I think proper way of saying that would be all swans that I have seen so far are white. Okay, but anyway, that's how we say it. That's empiricism, and that's also the scientific method. Okay, so modern science, as we understand, is an empirical science. Okay, in the sense that there is an element of falsifiability. Science never says that what we say is the truth, that it can never be refuted. They do not say so. They do not have that arrogance. They do not have that hubris. Okay, but then it doesn't mean that anyone can just say that okay, it's not the case. Someone who has to say that okay, this is not the case. So for example, someone says that evolution is wrong, has to come up with a better explanation of the said phenomenon. Okay, so that's how science works. On the other hand, for example, take the religious approach. They would say that okay, everything is creation of God. So how do you know that? They will not give you any empirical data evidence to say that. They might say that okay, this is the book that says so. Well, the book isn't enough, because there might be another book that says something else. Okay, so you have to give some physical evidence of okay, this is how it happened. But they don't care about physical evidence. Okay, only in science respect is given to physical evidence. And another important aspect of science is that the chances of falsifying a particular assertion. Okay, and that's the approach that had emerged in the work of John Locke, and then subsequently you have George Berkeley, then David Hume, who are other famous empiricists. Anyway, so this is the approach which was developed by John Locke. Okay, and we will discuss the rest in the next class, because I'm eating into the next class that you have. So if you guys have any confusion, then you guys can